What happens when a seemingly ironclad death penalty case unravels before the highest court in the land? Today, on World Day Against Death Penalty, we dive into the shocking case of Richard Glossip, a man who spent over 2 decades on death row. His fight for justice has now reached the Supreme Court, challenging the very foundations of our legal system. Brace yourselves for a story that blurs the lines between guilt and innocence and asks, can we ever be certain enough to justify the ultimate punishment? Let's delve into the background of this chilling case. Richard Glossip, a name that's become synonymous with controversy in Oklahoma's criminal justice system, was sentenced to death for a crime he insists he didn't commit. Back in 1997, Glossip's former boss, Barry Van Trees, was brutally murdered. The prosecution alleged that Glossip orchestrated the killing, hiring a man named Justin Sneed to carry out the gruesome act. For over 2 decades, Glossip has steadfastly maintained his innocence. Now, in a twist that's captured national attention, his case has reached the highest court in the land. But here's the kicker. Glossip isn't asking the Supreme Court to spare him from death row. Instead, he's fighting for something that could be equally life-changing, a new trial. This development has sent shockwaves through the legal community and reignited debates about the death penalty and the pursuit of justice. At the heart of this case lies a shocking revelation that threatens to unravel the entire conviction. Justin Sneed, the star witness whose testimony was crucial in sending Richard Glossip to death row, is now under intense scrutiny. New evidence has emerged suggesting that Sneed may have committed perjury during the trial, a bombshell that could potentially overturn the case. But the controversy doesn't end there. The prosecution stands accused of withholding vital information about Sneed's mental state and the medication he was taking at the time of his testimony. This isn't just a minor oversight, it's a serious allegation that strikes at the very core of fair trial practices. Imagine a jury making a life or death decision without knowing the full picture. That's exactly what might have happened here. Sneed's credibility as a witness is now in question, and with it, the entire foundation of Glossip's conviction begins to crumble. These revelations raise profound questions about the integrity of the trial process. If a key witness lied under oath, and if crucial information about his reliability was kept from the defense, how can we be certain that justice was truly served? The implications are staggering, potentially undermining not just this case, but public trust in the justice system as a whole. Now let's dive into the legal arguments swirling around this case. Glossip's attorneys have taken a strong stance, asserting that without Justin Sneed's testimony, the prosecution's case crumbles. They argue that there simply isn't enough evidence to secure a murder conviction, let alone justify the death penalty. But here's where things get interesting. The Oklahoma Attorney General, while maintaining a belief in Glossip's guilt, has taken an unexpected position. They're actually supporting the call for a new trial. Why? Because of the perjury issue surrounding Sneed's testimony. It's a rare move that underscores the gravity of the situation. On the other side of the courtroom, we have the court-appointed attorney. They're fighting to keep the conviction intact. Their argument? That the Oklahoma Court of Criminal Appeals has reviewed and upheld Glossip's conviction 6 separate times over the past 2 decades. They claim there's compelling evidence that Glossip commissioned the murder of Barry Van Trees. This legal tug-of-war showcases the complexity of the case. We have a defendant claiming innocence, a key witness accused of lying under oath, and even the state's top prosecutor calling for a new trial. It's a legal drama that could rewrite the book on how we handle death penalty cases. In a surprising twist, this case has shattered the usual liberal versus conservative divide we often see in Supreme Court decisions. The reactions from the justices have been as complex as the case itself. Justices Samuel Alito and Clarence Thomas, typically associated with conservative viewpoints, showed strong support for maintaining Glossip's death sentence. They expressed concern that the prosecutors in the case might be unfairly criticized 2 decades after the fact. Justice Thomas, in particular, voiced his discomfort with the lack of official interviews from prosecutors about their actions during the Glossip case. On the other hand, Justice Elena Kagan, often aligned with the court's liberal wing, emerged as a vocal supporter for Glossip. She didn't mince words when addressing the credibility issues surrounding Justin Sneed, the key witness. Kagan pointedly stated that Sneed had lied on the stand, emphasizing how crucial this fact is in a case that hinges entirely on one person's testimony. Adding another layer of intrigue to this already complex case, Justice Neil Gorsuch has recused himself. Before his appointment to the Supreme Court, Gorsuch served on the Federal Appeals Court that handles cases from Oklahoma. To avoid any potential bias or conflict of interest, he's stepping away from this decision, leaving only 8 justices to rule on Glossip's fate. This unusual alignment of judicial opinions underscores the gravity and complexity of Glossip's case, forcing us to look beyond political ideologies and confront the raw facts of justice and human life. As we look ahead to the potential outcomes of this case, we find ourselves in a unique situation. With Justice Gorsuch recusing himself, only 8 justices will be ruling on Glossip's fate. This odd number opens up the possibility of a 4-4 tie, a scenario that could have profound implications for Richard Glossip. In the event of such a tie, legal precedent dictates that the lower court's decision would stand. For Glossip, this would likely mean his death sentence would be maintained, despite the controversy surrounding his conviction. However, we won't know the final outcome for some time. The Supreme Court's decision-making process is deliberate and thorough. We're not expecting to hear the final vote and decision until late May or early June of next year. This leaves Glossip, his legal team, and those following the case in a state of suspense for the coming months. The delay also raises questions about the nature of justice in capital punishment cases. Is it just to keep a man on death row for months, possibly years, while legal debates continue? These are the kind of difficult questions this case forces us to confront. As we wrap up our deep dive into the Richard Glossip case, we're left with a stark reminder of the complexities and potential flaws in our justice system. This case, more than most, highlights the high stakes involved when it comes to capital punishment. On this World Day Against Death Penalty, Glossip's story serves as a powerful example of why the debate around capital punishment continues. It forces us to question, how certain must we be before we make the irreversible decision to end a life? Can our justice system ever be infallible enough to justify such a final punishment? The fact that this case has reached the Supreme Court, not to exonerate Glossip, but simply to consider granting him a new trial, speaks volumes about the intricacies and challenges within our legal processes. As we continue to grapple with these weighty issues, cases like Glossip's remind us of the ongoing responsibility we all share in ensuring justice is served fairly and without doubt. The debate surrounding the death penalty is far from over. Be sure to share your thoughts in the comments. What do you think about the justice system and the death penalty? Is enough being done to ensure fair trials? Let us know your views on this topic. And be sure to subscribe to the Real Crime Diary to keep up to date with this and other cases surrounding the death penalty. Until next time, stay safe and stay curious. Power, Pleasure, and Pain. A study of abuse through time. This book provides a detailed examination of how sexual violence and power dynamics have manifested across different historical periods, from ancient civilizations to the modern era. It explores how figures in positions of power used their influence to manipulate and exploit others, showing that the patterns of abuse we see today have deep historical roots. Many people struggle to grasp why abuse of power, particularly sexual violence, persists in modern society. By connecting historical events with contemporary cases, the book offers crucial insights into why such behaviors remain prevalent. The book analyzes infamous cases such as those of Harvey Weinstein, R. Kelly, and Dominique Pellicotte, drawing parallels between them and historical figures. This section highlights how the systemic abuse seen in recent times is not a new phenomenon, but part of an ongoing cultural issue. Through the lens of these modern examples, readers will gain a better understanding of how institutions, wealth, and power have historically shielded perpetrators from justice, contributing to their ability to continue harming others. The book explores the philosophy of libertarianism, particularly through the works of Marquis de Sade, to explain the disturbing ways in which pleasure, power, and cruelty have been intertwined. This provides readers with a deeper philosophical context to interpret modern-day scandals. Unlike other studies that focus solely on historical or contemporary cases, this book uniquely blends both, offering a full spectrum of how abuse is tied to power dynamics. It stands out by making philosophical connections that help readers understand the deeper societal issues at play.